So my whole position is very convoluted. I can't deal with an overly aggressive person outside of the courtroom. I can't tell my client that she can't be here, can't participate.
I didn't say she couldn't be here.
Right, and I know you didn't. But what I'm saying is that, to me, it's very clear what the situation is. I don't feel well internally. That's the problem.
I have some credibility concerns based upon what's been presented to me.
You took my words and you twisted them, Your Honor.
It's just a little bit harassing to me, honestly. That's the problem.
So Collins is not gonna show, but we have.
Oh, she's not?
No, after all of that.
Okay, well, I guess I'll do this one on the record and then we'll call them in. So
Okay.
if you want to just have them all come in,
So
that's
have them
fine.
all come in?
Yeah.
Okay.
Do the attorneys have a resolution or no?
He wants, no, he's going after default, so.
Okay.
Yeah, so they're talking right now, but I don't think there's a resolution.
Okay. We are going to go on the record in the matter of William Branson versus Heather Collins.
Good afternoon, Your Honor. My name is Smartened Up Lawyered Up, appearing on behalf of the defendant. She did request 8:30 in the morning at the last hearing because she works at 11:30. I didn't get notice of adjournment till Friday. I sent a subpoena to a witness on Thursday that I filed with the court. I've been trying to facilitate adjournment, but I have to officially ask the court for that.
Okay, so the court will note that I originally, we were trying to do a date, not today, and then counsel was going to be unavailable. And then I picked today's date, and it was my mistake of picking 8:30 because I had already committed to serve as a panelist on a career enhancements day at Wayne State University. So I was there this morning, and it was my fault I set that time. So once it was determined that there was a conflict, then communication was sent to your client. It was sent to you once we received your appearance. So that would be why you received that information on Friday, because that's when we received your appearance. And so there was plenty of notice provided to your client where she could have potentially just asked about going into work late, having somebody cover for her for an hour or two, I'm not sure. But before we get to the request for adjournment, did everything occur that was supposed to have occurred regarding, number one, I ordered the parties to brief the issue of no certificate of occupancy and collection of rent. Counsel, did you submit yours?
I did, Your Honor. I believe both sides have submitted memos, Your Honor.
Then I also indicated that
An inspection?
there was, yes, counsel, please let me make the record, that the parties were going to meet where Mr. Branson, they would have an independent, they could each have an independent person, so Ms. Branson was not to be present. And there was supposed to be an independent person there with Ms. Collins to go over what the issues were regarding the repairs that need to be made. There was permission to take some photos as well, but they were not to video or photograph each other. So, did that occur? Because I believe that was set for Saturday, the next day, Saturday.
Friday at 5 p.m.
Friday at 5 p.m.
Yes.
That's right. Okay.
In fact, it did occur. And what happened is that.
No, I don't know what happened. I just want to know if it occurred.
It occurred with the assistance of the wind-up police department.
I must state something for the record.
Okay.
Plaintiff was actually, I don't have a copy of a written order and I wasn't here, so I'm at a little bit of a disadvantage, of course.
Okay.
Plaintiff, of my understanding, was in violation though because he brought 2 police officers with him. This woman's already being, sexually harassed by her landlord. And,
Hold on.
Sorry.
Hold on a moment.
For safety
Your
reasons.
your client had made allegations regarding various types of harassment or assaults, indicating that those are being investigated. I don't have any information or basis for any of that. So counsel, please, we're not gonna go there.
I'm not trying to bring those claims to this court. I'm trying to explain that under the order and as you described it, there was supposed to be one independent person with each party. She's in significant emotional and mental distress because of her living situation. And then she has her landlord come with 2 police officers instead of an independent person. So plaintiff is in violation of what the court ordered. And it's having a deteriorous mental effect on my client, who's now being put through the ringer in court that, she's not credible because she's suffering from abuse.
Your Honor,
Well, first of all, I haven't said that your client's not credible.
Yeah.
I haven't said that at all.
Okay, sure. Fair enough.
may I address?
But I also, I will say from an outside perspective, that I don't know that there could be any more independence, as far as independent individuals than the police department, because they don't have any, stake in any of the games.
I appreciate that.
But the
And she's
issue.
been made aware of that, but the problem is that it's a very tenuous situation and the court ordered that one independent person come. And that's not what happened. The landlord brought 2 police officers with him. And that was video camera evidence. Even though it's from the police, there's a cam. They wear a
Body cam.
Yeah.
Okay, well, when I said no video, I meant I didn't want each of the parties to video the other party, thereby exacerbating any issues that were going on. That is what this court was intending, because your client was improperly recording the proceedings when she was here last time as well.
I understand.
So I wanted to make sure that neither party was exacerbating any issues or trying to instigate any provocation from the other side. That was why this court ordered no videotaping of the other individual. However, they could take photos of whatever issues needed to be repaired, but they didn't need to have the other person in the video or in the photo.
If I may just,
So my first thought is that if there's 2 police officers there as independent witnesses because they don't have a stake in any of it, I'm not sure how there could be any more independence by that. Did your client have another individual there with her?
honestly, I'm not sure, but she certainly didn't call the police. And if the order said you can have the police present, then I wouldn't even be discussing it. It's not that I'm trying to cause an issue. I need a simple adjournment. I need to get some fairness for my client. And
I'm not saying I'm not going to grant the adjournment, counsel, but I'm just trying to understand if any of the things that this court had ordered occurred.
that's hard for me to know precisely.
Well, but I'm also going to say this, that I don't know that there's a violation of the order, of this court's order regarding, and really, I didn't say they had to have an independent person. I said they could each have an independent person. I didn't say that they had to have an independent, I didn't say they had to have anybody there. I said, if you choose to have an independent, a person there with you, right? Because I thought that would probably be most beneficial for both of them. It has to be an independent person. And there are what they call civil standbys, right? So there's individuals that may be going to a property to, if the court ordered they can't return back to the home, they take the police with them to go retrieve some of their personal belongings or what have you. So I don't necessarily know that that's an improper person to have there during the time that the photos are being taken. I'm not sure.
Yeah. Guys, Judge, I think the reason she's objecting is because we've submitted the body cam of the police officers. Now, let me back up.
Wait. Where did you where did you submit the body cam to?
Your Honor, what we've done is that I've answered her motion to.
No, counsel.
It's part of
Where
it.
did you submit the body cam?
It's part of our response to her motion to dismiss. It was emailed.
Who filed the motion to dismiss?
My
Miss-
client filed an amended motion to dismiss.
And so
When
we,
did she file that?
Well, she does not understand the court system or e-filing, so I filed it as an exhibit because a brief was ordered. So my whole position is very convoluted. I have a brief and I have an amended motion to dismiss attached to it.
Your Honor, if I may,
Okay.
the motion was properly filed. It was properly filed, but not timely. You had ruled on that already. So you had a copy of the motion and anybody?
No, I didn't rule on the motion to dismiss. I say that I wasn't going to hear the motion because it wasn't properly, there wasn't proper notice. So I didn't dismiss the motion, I didn't do anything on that. I simply indicated I was not going to hear that on the 11th of February because it had not been properly noticed, there hadn't been proper notice. So I didn't rule on the motion, so let me just clarify that for the record. I did not rule on the motion.
That's correct, Your Honor. I wasn't inclining to say to you that you had ruled on anything. I was merely saying to you that when she appeared here in court, they took the motion and they filed it. And I was about to say exactly what you said, so I'm not going to repeat it. The next item I want to raise is the pragmatic part of this. In our response, we were able to locate the invoice in which my client first went to the city to apply, and it turns out it was in November. So this morning, I had my client go to the city again and request an inspection date.
Objection,
May I finish?
Hold on,
please don't yell at me.
excuse me. I expect that the attorneys are going to address each other respectfully and not yelling at each other.
I would like to finish my
So there's really not
statement.
anything to object to at this point, counsel. I'm just listening to what Mr. Dagger has to say.
I didn't get that.
This is the second time that's happened, and Your Honor, I just want to finish
What's the
my
second
statement.
time that's happened?
That she's objected in the
Okay,
middle
and I
of
just
sentence.
addressed it, so please continue.
Thank you.
Your client went to the city this morning.
My client went to the city this morning. My client was able to obtain, pardon me, Your Honor, there's a potential witness in the courtroom here who I think is going to be called. And what is your name? I'd like to identify
No,
who she is.
counsel, I'll find that out.
All right,
I'll find that out. Scott, can you go find out who? Actually, okay, Ms. DeClala, who is this individual?
I don't know. I haven't seen the video. I don't know.
Yeah, counsel, I'm just asking, who's the woman that's here in the courtroom?
Oh, this is, someone who's assisting me.
She's assisting you?
Yes.
So she's not going to be a potential witness
No,
or anything?
no.
Okay, and what is your name, ma'am?
Ariel, I'm a friend of
She's a
Ms.
friend.
Collins.
Okay, you're a friend of Ms. Collins, but you're not intending
No,
to testify?
no.
And so she's helping you out, counsel?
Yeah.
Does she work for you, or she's?
No,
Providing
she's,
information is small business.
yeah, and also
I'm sorry,
I like,
Filling her in on any facts that she might need because Ms. Collins isn't here.
Okay, well, Ariel, if she's called to testify, won't be allowed to testify then.
I'm not calling her.
No, I understand that, I'm
Yeah.
saying in the future or otherwise, because she's been
Yes.
inside here, so, okay.
all right, continue on, Your Honor. As I was saying, my client this morning went to the city and was able to obtain an appointment for next Wednesday between 9 and 2 to conduct all the necessary inspections for the compliance certificate. What I'd like the court to do, if we're going to adjourn this matter, is that I would like an order of the court allowing all necessary inspections to be conducted by the city next Wednesday between 9 and 2 as regularly scheduled. We have no specific control over the exact nature. Now, sister counsel had mentioned that there's a statute.
Hold on, before we get to that,
Yes.
we're going to address this.
Mhm.
All right, counsel, I'm not addressing, C of O, no C of O, or collecting rent at this point. I'm just asking, is there an objection to the city on February 25th between the hours of 9 and 2 p.m. to go to the home to inspect the property?
Yes, because they have to get in contact with my client first. In fact, I have from the city of Wyandotte, enforcement details. She submitted to them a copy of her lease. They were requiring that first. And under city ordinance, unfortunately, I don't have the point, but they have to get in contact with her directly. The city does. I would love to agree to that.
I don't understand what you just said. Do you, Your
The
Honor?
city has to get in contact with Ms. Collins.
Yes.
That's just not true, Your Honor.
Counsel, give me an opportunity, please,
Thank you.
without interrupting.
So this is from the SNA Online, and there's a summary here. There was a complaint, possible rental at the address. The tenant dropped off a copy of the lease and info for request. So now opposing counsel has scheduled the inspection.
Well, no, it doesn't sound as though they scheduled it. It sounds as though the city
Right.
told Mr. Branson when they would be there for the inspection.
Excuse me for misspeaking. It's my impression they have to contact my client.
in order to schedule it.
And, okay, is there something in the ordinance specifically that says that the tenant has to be present or the homeowner has to be present?
I'm not sure, Your Honor.
May I read the statute, Your Honor?
Okay. You have the ordinance there?
No, Judge, I'm reading the statute she cited to me outside.
No, I'm not talking about
Well,
the
there is
statute
no,
right
there is
now.
no such ordinance.
Well,
There is no such ordinance.
hold on.
Are you
So-
recording, ma'am? Your Honor, I think
Hold
she's.
on, ma'am, are you recording these proceedings?
No,
Okay, where's your phone?
it's turned off.
Okay, please present it over here for a moment. Okay, here's what I'm gonna ask you to do. I'm sorry, no, hold on, Dave, I'm sorry. Can you please, enter your passcode? You don't have to show your passcode to the court officer, but put it in a spot just so that you're only entering your passcode and nothing else, please.
I have to count it first.
It's completely off?
Correct.
Okay. All right, I'm just gonna, so it's completely off?
Correct.
Okay, please hand it to the court officer for a moment. We'll leave it up this way. You'll get it back you'll get it back when we're done.
Oh, wait a minute, no, you can't take my phone from me,
Yeah.
because you're not authorized to take my phone from me.
Yeah.
I'm not valid like you give me rules.
Yeah,
I would like my phone back.
yeah, all I'm doing is just making sure these proceedings are not being recorded.
Correct, and they're not, I have not recorded them.
Yeah, I'm just indicating it's gonna be here for just a couple moments,
Oh,
and then you're gonna get it back. I'm not saying it's for hours, no, as soon as we're done with this, you're
no,
gonna get
I
it
want my
back.
phone back. The
Yeah.
court is not authorized to take my phone.
Yeah,
Under what basis?
because there has been previous recordings.
Not by me.
Can you please not interrupt the court? By Ms. Collins, there is a concern that the proceedings are being recorded. So I'm just trying to alleviate any of the concerns, and it's just gonna temporarily stay right here. That's all I'm saying.
Can you please, under what law that gives the court?
Under the judicial discretion that's given to the courts under the court rule that allows phones to be brought into the courts.
That you can take my property?
The court has judicial discretion as to whether or not to allow individuals to keep their phones. If you wanna go put it out into your car, you can certainly go do that. It's just not going to be in the courtroom. So here, can you give her back her phone? You can go put it out into your car.
So because I'm friends with Ms. Collins, you're concerned that I will be recording?
No, ma'am, it's not because you're friends with Ms. Collins. There was a concern raised that there's potentially recording. You stated that your phone is off.
It is off, so
Okay.
how could have I been recording if you make it pay? I looked up here, my phone
Ma'am?
is shut off.
Ma'am, this court has judicial discretion to ensure that there isn't anything improper occurring regarding any recording.
Correct, and it isn't.
Ma'am, it has been raised, so all I'm doing for purposes of the proceedings
Right.
is for you to go take the phone out to your vehicle. I'm not arguing with you any further. I've explained the court's position, it can go out to your vehicle,
I will take it up from you.
okay? So, pursuant to MCL 125.526, 8B, the inspection is scheduled for February 25th from 9 AM to 2 PM.
I'm sorry, it's 26, Your Honor.
You said the 25th,
My mistake, I misread it, it's the 26th.
26th,
26, correct, 226.
okay, which I believe your client does not work on Wednesdays. If I recall from last week, I think she.
Thank you for that consideration. You may be more aware than I am.
I could be wrong, because I got
Okay.
the time wrong this morning when I said the
Yeah.
matter, but I'm pretty sure that she works on the weekends and then on Tuesdays.
And I appreciate your patience.
Yeah, no problem. I was going to have everybody come back, well, I prefer for everybody to come back Friday, because, the inspection itself, I'm not saying it's a moot point, because obviously the property has to be inspected, but for these purposes, I don't know that has a bearing one way or the other with what this court's ruling regarding the escrowed money. Because I believe that the issue that we have left to address is where does the escrowed money get released to whom does it get released? And Ms. Collins raised a concern regarding overpayment of the utilities. And so there's that issue. So counsel, when the two of you were out in the lobby waiting for the court to call the case, did you go over any of the utilities?
No.
No, Your Honor. Well, we can try to address it before the hearing on Friday.
Okay, I mean, since you're here, you might as well, while you're out in the lobby.
We can.
Maybe look at it, or you can
But
maybe
the
go
problem
over
is-
to the offices.
Ms. Collins isn't here, and because she's not here, I haven't been able to get anything directly answered. So I don't know how constructive it would be.
Well, counsel, were you provided any utility bills?
I was. I might need a moment and I might have to do it over the phone because there is some aggression outside in the hallway and I'm not comfortable.
I'm sorry, aggression?
Yes. I don't know how much I'm allowed to disclose because it's settlement negotiations.
I'm sorry.
Okay, all right, your aggression by,
Opposing counsel,
okay, verbally?
physically,
Oh, my Lord.
Okay, what specifically?
he was stepping, the woman, Lily, who just left the courtroom, you know, even if she shouldn't be involved in the conversation, I respect this, but he was physically stepping in front of her and pushing her back. I witnessed it.
That's not true, Your Honor. That's a
is.
false statement. That is a false statement, Your Honor. We were having a private conversation. This young woman comes up and starts interrupting, getting into my face. So I turned my back, not wanting to confront her, because I didn't want to deal with it. You can see why from earlier what happened. I just don't want to deal with it. It's me and her. She's a very kind human being. I don't see any reason why anybody else can be involved in
Referencing Mr. Kalala.
I am.
For the record.
Yeah, you know, we've talked on the phone. She's a tenant in the building I built. The guy she works with is my childhood
This
friend,
is not
Scott.
relevant.
It is very relevant.
No,
Finish,
it
please.
isn't.
Ma'am, they're just producing issues for no reason at all. I'm willing to have any conversation with anyone, particularly Mr. Gullah, because I view her as a very kind human being. And I'm not sure where this hostility is coming from, other than the distraction for further noise.
Okay.
And that's something that
Hold on.
I'm trying to avoid.
Here's what I'm going to say. So, Miss Ariel or Miss Lily, I'm not sure what her name is, I thought she had.
Ariel, I'm sorry, Ariel.
Oh, okay, she really has no point really in participating in the conversation between you and counsel. But what I'm going to say is we have a court officer that can be near the both of you, if, you know, for some more, so that you can feel a bit more comfortable.
Okay.
So we can do that,
If
because
you
I
could
do
be-
think it's imperative that as much as it can occur for counsel to be in the same room showing the paperwork that's there to be shown on both sides, as opposed to, you know, getting an email or talking on the phone or something like that. So if there was a court officer that's there, would you feel more comfortable with that?
A little bit, but frankly, you know, opposing counsel is a fantastic orator, but I'm shaken up. I'm shaken up, you know? I'm not trying to cause a distraction. I can't deal with an overly aggressive person outside of the courtroom, even if it's, you know, when people aren't looking. If it's over the phone, fine. If it's words, fine. I know that Miss Ariel is not my technical assistant. I know that she's not technically involved in any aspect of this case as a party, but I don't feel well internally. That's the problem. And I need to go forward on this motion, this amended motion to dismiss, but I can't tell my client that she can't be here, can't participate. If she's insisting on being here, I have to respect that.
I didn't say she couldn't be here.
Right, and I know you didn't. But what I'm saying is that, to me, it's very clear what the situation is, and that if there's an eviction action, it needs to be done differently.
It's very clear.
Yes, I'm not gonna get into the substance of the matter of the amended motion to dismiss.
Okay.
I don't know what she's
Well,
I
okay,
don't understand what's going on here.
so
And
everybody can be back Friday?
Yes.
Your Honor, with all due respect, counsel here has demonstrated a great deal of agitation to me, and now I'm in fear.
What are you in fear of, Mr. Dagger?
I'm in fear of being anywhere near counsel and being accused of something. So, I'm just letting you know on the record what I'm now fearing. I'm sorry that I'm a man and that I am who I am,
Gender has nothing to do with
but
that.
that's what she was suggesting, Your Honor.
No.
Okay.
Thanks again for all your patience.
So Judge, in terms of the inspection, it's not going to be in written form. Do you want us to submit it to you? We can do it now if you want.
Submit what, the
The
communication
order,
from
the order of inspection, Your Honor. We can prepare relatively quickly and submit the signature, so that,
Oh, you can bring it on Friday, that's fine, because it's still before Tuesday,
yes, ma'am, we'll do that.
okay?
All right,
Right, anything else?
No.
Okay,
thank you, Judge.
all right, thank you. Have a good day. Let's
You
go
too.
off the record for a moment.
I'm not talking to you.
We've got utilities on Friday. Please bring all the documentation with you.
Ma'am, with regards to utilities, I can have my assistant talk to her directly, or we can exchange emails. I won't be part of the conversation. I don't want to be physically in any place near her. So how do you, I'm offering her an opportunity to suggest she can talk to my assistant Ashley, or we can go back and forth with email. I'm not quite sure what would be more efficient.
Well,
In 32 years of practicing.
hold on, I'm not gonna get into all the, I'm not getting into all the dissertation. Do you wanna speak to Ashley?
I would speak to anyone, I just, I mentioned he's being physically aggressive and now it's being pushed over onto me somehow.
Who's
So
pushing
I
over on you? I mean, the court's not pushing over.
I just was no, not the court, opposing counsel, I was just mentioning I can't talk to him outside right now, I need a second to breathe.
I don't want
What
to
about,
That's all.
please, hold on, what about speaking with Ashley? You should, and the two of you can go over the utilities and kind of see where you're at. And then Ashley can get her steps in, go back and forth with Mr. Dagger, somewhere where he's somewhere else, and the two of you can have a conversation, you meaning you and Ashley, can have a conversation regarding the utilities.
I have a panic disorder.
Okay,
Yes, I can go sit with Ashley.
okay, all right, so
I'm gonna
Ashley,
stay here.
I'm familiar with everything in the case and I will talk with her this.
okay, and then if there's any
I will go
questions,
back.
whatever, I'm gonna have you go back and forth with Mr. Dagger.
Yes,
But if the two of you have to have a conversation, then when you have the two of you, have that conversation outside the presence of, Ms. Teklala and Mr. Dagger, I'm gonna have you, because I have some other matters that I'm handling here, so if you have to have a conversation, then you have to step outside.
What I'll do is I'll sit next to the court officer, Your Honor, near the entrance, and I'll sit there and go back and forth.
That's fine,
I'm
we can open up,
not interrupting your court.
we can open up the, either the defense attorney room or the prosecutor room, so the two of you have a desk. that
Okay, thank you.
you can- Okay, thank you, we'll see you all on Friday. And Mr. Dagger, when they're discussing, whatever they're discussing, please do not make any comments, okay? At all, don't make any comments, or anything. I'm not suggesting that you will, I'm just,
Judge, I'm a father of two girls,
counsel.
and you have no idea how upset I am.
Counsel, I want everything to go as smoothly as it possibly can, okay?
I think you know how I feel.
Thank you,
Thank you, Your Honor.
okay.
3 days later.
When they come into court with us, do you want me to check phones to make sure that they are all?
Yes, 100%, please.
Okay.
In fact, you can do that before they even come in the courtroom.
Well, then they can turn back on, they won't know.
No, I mean, as they're coming in the
As they
door,
come in.
one by one, they can come in one by one, and you can make sure their phones are off.
Yeah, okay. You know why, right?
You've become the phone police.
Okay. The court is going on the record in the matter of William Branson versus Heather Collins. So today is the adjourned date. There is an allegation that Mr. Branson cannot proceed because he does not have a valid C of O. Ms. Collins, in her motion, references a specific paragraph that would not allow Mr. Branson to continue. So counsel, I understand that your client filed this, but you also did indicate at the last hearing on Tuesday that you were relying upon the motion. And so what part of that would require this court to dismiss this action?
Your Honor, this action must be dismissed under MCL 125.530. That is the Michigan law that requires a certificate of compliance to be held by a landlord. Under paragraph 5, it states that an action may be maintained where there is not payment into an escrow account. So,
I'm sorry, what was that? An action what?
May be maintained, an action to recover possession of the premises may be maintained where there's not payment into an escrow account.
I believe that 125.530 would speak specifically to the issue as to where the monies go from the escrow account.
Your Honor, if I may.
Just one moment, please.
Sure.
Right now, I'm addressing the motion to dismiss portion of it, not the portion that we're going to address regarding the payment of the escrow account. So as to the motion to dismiss, Ms. DeClala, what in paragraph 7 would support the request to dismiss this action?
Okay. So I'm referencing 125.530 generally. This was brought up in the defensive responsive pleading and it was relied on quite heavily. It's actually stating that the property can't be legally rented out when it doesn't have a certificate of compliance. You know, that's pretty obvious to us. The issue here is whether an action in eviction can be maintained a summary proceedings in local district court where there is not a valid certificate of compliance. There's certainly not a valid certificate of compliance in this case. We're all aware of that. There's an inspection scheduled with the city in order to correct for that. In particular, I'd like to draw your attention to the court rule for these proceedings. In particular, I'm referencing MCR 4.201.
So you're relying on the part stating that the plaintiff is not in compliance with applicable state and local health and safety laws?
Correct. And
okay, so what local health and safety laws are not in compliance?
Okay, that would be the City of Wyandott's Ordinance 181.020. No person shall lease, rent, or cause to be occupied a rental dwelling or rental unit unless there's a valid certificate of compliance.
Okay, so does that fall under state and local health and safety law?
Yes, it does.
Okay, how does that fall under there? Because that seems to me to be an ordinance that the city can then enforce against Mr. Branson.
Absolutely, Your Honor. But you know, that's exactly to my point. It's something that the city can enforce, and this is meant to protect the safety of its citizens who are renting out residential units. So it's in direct conflict with the court rule that requires when you file a complaint in these matters for the landlord to represent that the residential property is being kept fit for the intended use.
Okay, so what's in direct conflict, counsel?
Okay, what's in direct conflict is that the certificate of compliance is required to assure the health and safety of the citizen living in the unit. So in order to file a complaint and represent that it was kept fit for residential use, not only is it required under local law for the City of Wyandotte under section 181.02, but also under the court rule for filing these actions, the complaint must allege that the premises is kept fit for the intended use and it's in reasonable repair. So as you mentioned, then it goes on to state in compliance with applicable state and local health and safety laws. Certainly, 181.020 is a local ordinance that's protecting the safety and health of its citizens. That is a local ordinance that's meant to do that.
So as it relates to not having a certificate of compliance filed with the city, I don't find that the remedy for that is to dismiss this action. So on that point, I'm going to deny the motion. You also allege the property was not kept for tenants' peace and enjoyment required by law. And then also that it was not kept fit for the use intended. So I can't rule on that portion of the motion until I take testimony on those matters. Your clients raised the issue that the property was not kept fit for its intended use. She cites, for example, a bug problem. I'm not sure if there was any other problems. Okay, not finishing the kitchen. So other than those two issues, are there any other matters that your client is alleging where the property is not kept fit for its intended use?
May I allow her to speak on it?
Well, first I'm asking you, counsel.
Okay. There's a mold issue in the basement causing significant health issues.
Okay, hold on just one moment. All right, so you're alleging it's causing significant health issues.
Your Honor, my client is asking if she can sit down. She's not feeling well.
Okay,
Thank you.
all right, so let's talk about this. All right, so you're alleging a mold issue in the basement causing significant health issues, a bug problem. The kitchen was not finished.
There is a window in the basement that is almost fully detached from the front wall, allowing, a lot of environmental issues like wind, water, rain.
Okay, what else?
I would like her to continue if it's okay.
Well, counsel, I'm asking you because you're representing her, so I'm
Right.
asking you right now. So what
Okay.
else?
The basement floods. There are certain fixtures within the house, such as vents, that are completely detached from the wall. There is one room with no heat or air conditioning. I'm not sure that's an exhaustive list, but that's what I'm aware of.
Okay. Did you send any of this communication over to Mr. Branson's attorney before today?
Oh, there have been
There's also more than just that, yes.
Hold on, ma'am.
many exhibits filed, but the problem is that I have.
So that wasn't my question, counsel.
Mhm.
My question is, did you specify these concerns, the ones that you just stated? I understand it may not be an exhaustive list. Did you specify these concerns with Mr. Branson's attorney? Yes or no?
I did not.
Okay, so counsel, let's, actually, Mr. Cloud, what's the bug problem? Your client alleged in the motion a bug problem.
Yes, she's having to shower with swimsuits on. The bugs are so intense in her shower. I filed quite a bit of exhibits. Contained within those, there's text message evidence that she's asked her landlord several times to fix the bug issue.
Okay, which page of the exhibits are we referencing on that one?
Your Honor, respectfully, I have a time limitation today. If we're gonna have a full evidentiary hearing, is there any chance to be able to prepare for that and come back, or no? There's a lot of exhibits.
This is your client's motion to dismiss, so.
Motion to dismiss, yes.
Right, but one of the
Okay.
elements of that is that your client claimed that it was not kept fit for habitability.
Okay.
So I'm trying to, I said I couldn't, make a ruling on that until I took testimony, so that's what I'm doing.
I don't have a specific page number, but these were filed, and that was on Tuesday.
Is there a date on those text messages?
Yes.
Okay, what's the date?
It's June, July, and August.
June, July, and August, okay.
Your Honor, it's the 102nd page of the document that you filed at 8:03 in the morning on Tuesday, just before the last hearing. Page 102, Your Honor.
Okay, I'm not sure if I have that. The first one I have is dated Sunday, July 14th at 10:57 a.m. The first one says, sorry to text so early, those bugs are back in the tub, I seen them yesterday sprayed what I have and they are still there today, these things don't want to die. What type of bugs are we talking about?
Your Honor, there is a page before that.
Oh, Tuesday, June 18th.
Correct.
Count at 3:43 p.m. Also, if you could look at these little black spiders, I have all in the bathtub and the bathroom floor tomorrow when you're here, I appreciate it. I tried to clean them out of the bathtub. Was there any communication between the two of you regarding these bugs after June 18th?
Certainly. Yes, ma'am.
Okay, where are those?
I don't know, but we could certainly.
Yeah.
Well, first, if you're asking this court to accept these exhibits, why am I getting partial conversations?
He asked me to take care of them myself.
Okay, that's not my question. Counsel, you've submitted these as exhibit. So this court can view the communication between the parties regarding the bugs, and these are an incomplete transcript, so to say, of the text messages.
I don't. You might have not actually responded.
You might just put your phone away unless the judge asks you.
Was there additional communication after June 18th and before June 27th regarding the bugs?
I can't recall.
Mr. Branson?
Yes, ma'am.
Okay,
Your Honor, I'm sorry, I don't mean to interrupt you. I think our administrative assistant has them and she can put them on the screen for you if you'd like.
I object. I need to be able to review exhibits in advance.
well, counsel, you've offered the text messages between your client and Mr. Branson as a way for this court to determine whether or not there's an issue of habitability and the property was kept fit for living, and I have partial conversation here. So I need to have the full conversation. So this is new for everybody because, well, your client has everything printed up. Or do you have those printed up, ma'am?
I'm going to look if they're in here. If they're in this file.
Your Honor, she has them and she did.
Counsel,
They might not be in this file.
we're not gonna have any communication right now until we see if these are in here.
Your Honor, I have more complete communications from earlier in July, the 13th and the 14th.
I'm looking for June, between June
I'm
18th
sorry,
and
yes.
June 27th.
Okay. That's July as well. Just looking for between June 18th and June 27th. I obtained a more comprehensive view. It's still not clear what the entire conversation is.
Well, here's my question. Why am I receiving as exhibits partial conversations?
That's a good question.
Ms. Collins?
Just to show that I found that there is a bug problem.
No, hold on. But counsel, you've submitted these, right?
Yes,
Did you look at them before you submitted them?
I did, yes.
And did you notice that there is a huge gap between June 18th and June 27th?
Yes, and I was anticipating, laying a foundation and questioning a witness.
Which witness?
Both Ms. Branson, or I'm sorry, Mr. Branson and Ms. Collins.
Okay. If text message conversations are going to be proposed for an exhibit, and this court is being requested to rely on the text message conversations to prove something that you're alleging, I need a full and complete conversation, not piecemeal. I'm not accepting those if they're piecemeal. Mr. Branson,
Yes, ma'am.
your testimony is that you have these on your phone.
Yes.
Okay.
Yes.
Your phone is out in your vehicle?
Yes, ma'am.
All right. Please go out to your vehicle to grab your phone.
Yes, ma'am.
Thank you.
I have to object, because you can go into a phone and line item delete text messages.
Counsel, I'm very aware of that. I just right now want for you, the two of you, to see if those exist and to look at those right there.
Okay,
Okay?
okay.
Your Honor, if I could just make a brief argument regarding this. The defendant is claiming a defense to this eviction proceeding with her motion to dismiss them. She carries the burden of proof in this case to prove what she's saying is true. My client carries no burden to prove her case and defend himself against her case. Defendant came in here today utterly unprepared. And quite frankly, I believe that she came in here with the intent to do trial by ambush by providing intentionally only piecemeal copies of these text message records.
Counsel, I'm aware as to where the burden lies as far as this motion to dismiss. Right now, I'm not necessarily stating that I'm looking to see the truth of anything within these text messages. Right now, I'm trying to verify something. So please, if you will just please humor me and follow this exercise.
Of course, Your Honor.
Okay,
Thank you.
So, counsel, were you able to view Mr. Branson's phone for the dates between June 18th and June 27th?
Yes.
Okay, and are there text messages between the parties on those dates regarding the bugs?
There are several text messages.
Are there any regarding bugs?
Yes.
Okay. And so just by way of, just by yes or no, are there any missing text messages on the Branson versus Collins matter when both counsel were comparing the phones?
No, Your Honor.
No.
Okay, very good. Are any objections to the court reviewing the text messages, since now we know that there are not any missing text messages between those dates?
Your Honor, I have no objection about reviewing the text messages. However, I would say that it is not, we reviewed what you've asked us to review, which is between July 18th, June 18th, and June 27th. However, there are other text messages past that date that are relevant to this conversation about the bugs, including text messages where the bugs have been completely eradicated.
Okay, and I'm not saying that we won't, I just wanted to get those dates, the messages between those dates secured. Are the messages regarding that Counsel Amy is referencing, are those included in the documents that were submitted?
No, I'm not aware of that.
You're not aware of what?
The eradication of the bug issue.
Okay, whose phone are those on?
They're on my client's phone, but they should be on her client's phone as well.
So, counsel, you both had an opportunity to review the subsequent text messages after June 27th, correct?
Correct.
That is not correct, Your Honor. The defendant walked away and did not allow me to actually look at her phone. She literally walked away from the conversation. And
don't interrupt, please.
And I asked her counsel whether or not there were text messages subsequent to the one that we have on August 18th. We have not been able to, because we have.
August 18th?
Yeah, so we have a text message specifically on August 18th. Hey, the guy came out, he sprayed, this should take care of it. She says, thank you. That's the last text message my client has related to any book issues.
All right, okay. Do you have any of those text messages, ma'am?
Yes, Your Honor.
Is she allowed to be using her phone at this moment?
As long as she's just looking through her text messages. So, Mr. Klala, did you see on your client's phone the part about the bugs being eradicated and your client saying thank you?
I saw that conversation. I don't consider it proof of any eradication of a
That
bug
wasn't my
issue.
question.
Okay, I saw what you're referring to.
Okay. Did your client allow Attorney Amy to view the text messages that you were viewing?
No, but that was an accident, Your Honor. She walked away. I thought we were just confirming that they both had that text message.
We were, but well,
Okay.
you were, the two of you were. How is Attorney Amy supposed to do that if your client walked away with her phone?
Okay, yeah, you're absolutely right. I'm sorry.
So the message that somebody came out to spray for the bugs and your client saying thank you, that doesn't mean that those were eradicated.
No, they weren't. There's still a bug issue.
Okay, when did your client then re-notice Mr. Branson regarding the bug issue?
I have to ask her the specific date if she can recall it.
Okay, here's some concern that I have here. Your client is alleging this matter should be dismissed because the home is not habitable, okay? Or it's not fit for living properly. Did you find the text message? Don't stop looking until you find the text message, please. And you've submitted a plethora of text messages that are incomplete. So I should not have to be the one to essentially babysit step by step how the evidence should be brought forth and communicated between counsel. I should not have to do that. But yet, I am having to do that. Because your client is giving you partial information. I don't know if you've attempted to get the information from your client and it's not able to be given to you at the time you're asking. I don't know. But to ask this court to dismiss this matter.
They didn't say they were eradicated.
What does it say? Is it right there?
Yes.
Okay, show Miss Amy what that is. Attorney Amy, the phone.
They said they're harmless.
That's August 18th?
Yeah, and that's not if you'd like, Your Honor, I'll read the entirety of the text message into the record and they can confirm whether it's accurate or not, if that's.
Is that?
This is August 18th. Never did they say they were
Ma'am,
eradicated.
I'm
They
not
said
asking
they're
for your
harmless.
testimony. I'm asking if you have pulled up the text message
Yes.
that is being referenced regarding
Yes.
somebody coming to spray for the bugs and you saying thank you.
I didn't say thank you, but yes.
Your Honor, the very.
Yeah, I did say thank you. You're right. I did say thank you.
Okay, so I'm going to have you follow along on your client's phone. Attorney Amy, please read into the record
Thank
the
you, Your Honor.
date and time and who it's from, please.
Thank you, Your Honor. From Mr. Branson to Ms. Collins on Sunday, August 18th at 2:40 p.m. He identified the bug as a springtail, basically like a gnat. They don't bite, sting, or do anything. Totally harmless. They like damp areas. He recommends every time you shower, use the vent. The underside of the tub is totally dry when we ran a camera under it. Spray for them. Google springtails. This should take care of them. Hung the mirror and your doorbell also. I ordered some LED lights. It says LED, but I take that to mean LED lights for the basement as well. Untimed response by Ms. Collins. Thank you so much. When you have a moment, can you please show me how to take the doorbell off and I can hook it to the Wi-Fi and app. Sorry I tried and I felt like I was going to break it. Also, the mirror looks great. Thank you so much. I appreciate it. And then there's one response by my client on the sheet that I have that says there's a small orange tool in the box. Use that to unscrew the set screw on the bottom of the doorbell, then slide it up.
Okay. Did you then send, so that sounds to me as though Mr. Branson fulfilled his obligation at that time as it relates to the bugs. Now, did the bugs return?
Yes.
What date?
They've been returning off and
No,
on.
ma'am, it's your burden.
I don't know the exact date.
Ma'am, it's your burden. You have filed a motion to dismiss and you're alleging that there's bugs and that's a reason why Mr. Branson should not have checked box number 7. So what other dates have the bugs returned that you communicated that to Mr. Branson?
I can't give you an exact date. So I'm not gonna lie and make one up.
Okay.
If that's what you want me to do.
No, it's not. I don't want you to lie and make one up. Okay, so we'll move on from the bug problem. Ms. McMullen, what you got there?
Exhibit 6 contains text messages about the kitchen.
Okay.
Your Honor's probably not gonna love it because it's the similar format as before.
Well, you're correct. July 24th.
Also, I'm at a little bit of a loss. I thought we were arguing a motion for summary disposition based on the certificate of occupancy. So I was intending to call witnesses for a, evidentiary hearing and cross-examine them and lay a foundation for these exhibits for those underlying issues.
Your Honor, I warned opposing counsel that she was mistaken. I gave her fair warning via email, in writing. I think this court is actually purview to those conversations. I think they have happened in line with the conversations related to the proposed order that Your Honor had the ability to view this morning. And instead of, double checking and crossing her T's and dotting her I's, Ms. Duffala came in here unprepared for this hearing after submitting documents that are inappropriate and abjectly in violation of the Michigan court rules and rules of evidence.
Your Honor, I'm a little tired from opposing counsel trying to throw the evidence under the bus and say this, that, or the other thing, when all I'm saying is there's procedure to be followed for a motion for summary disposition based on immunity granted by law compared to a full evidentiary hearing while I'm calling the witness.
What immunity are we speaking of? Because because the court ruled on, in fact, let me pull it up. The court ruled when the parties were first here on the 14th that Miss Collins was going to be relocating. She, number one, stated she wanted to relocate, and the court ruled that the plaintiff is entitled to recover possession of the property. You also, counsel, at that time, wanted to address your amended motion to dismiss. So that's what we're still on. We're still on the amended motion to dismiss. I started with that because if I'm granting that, then the rest of the matters appear to be moot as far as that goes. However, so that's where we're at right now. So that is what we're here for. And I will also make a statement regarding the evidence. And counsel, you've submitted evidence that is incomplete. You've submitted these exhibits that are incomplete.
I suppose I was just looking for clarification from the court why. To me, this is a motion for summary disposition under 2.116C7 and C8. It's not an evidentiary hearing, so I have testimony, and to not be able to, take testimony of someone that I'm calling with evidence that I can build a foundation for, it's just procedurally, I can't understand. I do understand that you're allowing, and thank you, allowing to hear argumentation on habitability for the number 7 that was checked. I do understand that and appreciate that.
A motion for summary disposition wasn't filed, so this is not a summary disposition matter. A motion to dismiss was filed by your client. An amended motion to dismiss was filed by your client. You're relying on that motion that was filed and then submitted additional exhibits. So we're back to the kitchen.
Could you do me a favor and give me the court rule for the motion to dismiss?
The court rule?
Yes.
Your client filed the court, I don't know what she filed it under.
I don't think she filed it under any court rule.
And Your Honor,
well, then I guess, you're claiming that it's, let's see here, property item 7. That is what she referenced. Or, I'm sorry, item 7, non-payment of rent for residential property, item 7.
I'm just asking for the court rule so I can have some guidance in terms of the motion to dismiss compared to my interpretation of it substantively was more of a motion for summary disposition. So if I could, if I had the court rule for the dismissal that we're operating under, maybe I could have more clarity there.
Well, presumably I'm operating under 2.119, which is a motion, and your client filed a motion to dismiss. 2.116 is a motion for a summary disposition, and there has to be a 28-day notice, and there has to be a time for response to be filed, affidavits, and all that. This was not filed as a motion for summary disposition. This was not filed that way. So we're proceeding as a motion to dismiss.
I don't believe she filed it in the first place. I filed a brief.
Who filed the motion to dismiss, this handwritten motion? Who filed this motion?
That is an exhibit. It wasn't filed. You had ordered briefs, and she had written that before.
No. This was filed.
Oh, fine.
This was filed.
Okay.
Prior to your appearance, counsel, this was filed because this is what we did not proceed on February 7th because there hadn't been sufficient notice to plaintiff.
Okay.
So that is why we are handling it in its entirety now, because now everybody's here, everybody's present. That is what we're doing. So, but if you want to stipulate that the property was habitable and we don't need to have further inquiry regarding item 7, then we can proceed with the next issues, that's fine. Or we can continue to proceed with whether or not the property was kept fit for its intended purpose pursuant to number 7, the complaint for recovery of possession of the property.
Okay, I would like to request a continuance, please. For the reason that I was under the impression we were arguing in terms of the disposition of this case under the law in regard to MCR 4.201 and MCL 125.530. I'd like to re-subpoena the witness that I had subpoenaed for Tuesday's hearing in order to have her present.
Which individual is that?
It is Kelly Roberts. She works for buildings for the city of Wyandotte.
Okay, you subpoenaed her to be here this past Tuesday?
Yeah.
Was she here?
No, she wasn't.
No, she was not. Okay, so what does Ms. Roberts' presence or testimony, what's the relevance regarding the motion to dismiss?
I want to ask her about any former inspections of the property.
That would be as it relates to the money held in escrow as to where that goes, but I don't know that I need her testimony for that, but that I'll defer that for just a moment. What does that have to do with the motion to dismiss?
What it has to do with the motion to dismiss is, again, going back to how this is a little convoluted in my brain, because you have MCR 4.201, which dictates that residential properties have to be kept fit for their intended use and purpose, and habitable as it relates to number 7. Then you have MCL 125.30. So to me, if there's no certificate of compliance, and then on top of it, factually, it's not being kept fit for use, especially with the amount of evidence and the amount of issues. If I have testimony from a city employee stating that there's a history of problems at the residence, or some further information that could push the burden of proof so I can actually get my client the justice that I'm attempting to get now, that's why I'm asking.
If I may briefly respond to just her oral arguments, if it may please the court. And the reason that witness didn't show up last time is because sister counsel subpoenaed her incorrectly. A subpoena was submitted to the city via email 3 days before the hearing, when the court rule clearly requires 7-day notice with personal service of a subpoena for a witness to appear. So sister counsel didn't even do that correctly to get her witness here.
I sent an email to the witness as a courtesy. I sent it out, priority mailing, but I was retained 4 days before this was. I'm just a little tired of hearing, I didn't do my job, I didn't do my job, I didn't do my job. When I'm not talking about that. Yes, there's a burden of proof. Yes, there's evidence. I'm talking about being able to fairly get testimony from the witnesses I intend to call and to be able to lay a foundation for my evidence. Because a lot of this is trending into what my client's defenses are. It's not relevant to the motion to dismiss, it's what her defenses are.
Okay, what are your client's defenses?
Well, my client's defenses obviously primarily is that it wasn't fit for use and habitability.
Okay, so your client is stating that when this complaint for non-payment was filed on January 3rd, that the property was not in a habitable condition.
Correct.
Okay. So you subpoenaed Ms. Roberts, you're intending to call Ms. Roberts as a witness to address the habitability of the property.
Correct.
Okay. When did she go in to look at the property?
I don't think that she has.
So then how would her testimony be relevant?
Because she's the custodian of records for the buildings department.
Okay. But if she has not looked at the property, how can she determine what issues would affect habitability?
I would be more than happy to talk about what issues affect habitability after the inspection is done that's scheduled on Wednesday. But I'm absolutely insisting that someone from the city provide testimony related to this property.
Okay. Has the property been condemned?
No, Your Honor, it has not.
Okay. So have there been citations issued to Mr. Branson regarding property maintenance violations?
No, Your Honor, it has not.
Has there been any documentation that would suggest that the property in and of itself is not habitable?
No, Your Honor, there hasn't.
Ms. Taqvala?
So I have significant evidence from my client. There are several pictures that have been submitted to the court.
Okay, let me clarify. Any of those photos, do those render the premises inhabitable?
Yes, the mold
Which-
issue.
The mold issue, okay, when did the mold issue begin?
Before I moved in.
Okay, did you look at the property before you moved in?
Yes, and I asked him, he told me it wasn't mold, and he
Okay, did you have a mold test done?
No, I believed him.
Then how do you know that it's mold?
No, I've now since.
Okay, where's the mold test?
I'm getting it back right now, and I'm also.
When did you
getting
have the
it
mold test completed?
About 3 weeks ago.
Okay, so where are the photos? So the photos had to come from somewhere. Were they on a phone?
No, and I do have color copies.
See the color copies, please.
I have black and white here.
Well, then why don't we have the color copies here?
Because I need a continuance, I need more time to adjust my exhibits and to be able to run this effectively.
Well, if there's an allegation of mold, I'm not sure why the color copies weren't brought. Ma'am, when did you become concerned about the mold that you're alleging?
After I got out of the hospital, and they told me that it could be something in my house.
What could be something in your house?
That gave me my disease.
What disease is that?
That I have this low vitamin thing that my body's not reproducing.
Okay. Okay, well, when did you get out of the hospital the last time when that was stated to you, ma'am?
In October, the
Okay.
last week of October.
Okay, and so you ordered the mold test 3 weeks ago?
With my doctors that they finally put it to me, I first smelled something when I first moved in, and he's like,
Right, that's why I have the dehumidifier.
yeah, that's why I put it in there.
Okay, right, and
But
that's
I was
established.
I was never told until like 3 weeks when I moved in that the basement flooded. He sent me a text, oh, by the way, the basement floods.
Okay, hold on, because I don't find that there's flooding in the basement. But I still haven't heard any testimony that would support your client's motion to dismiss on number 7. Now, whether or not the monies go to whomever, that's a different story. Okay, you're saying that you didn't have room with heat. You have a room without heat and air conditioning, upstairs front room.
Again, I'm looking to call a witness and.
As it relates to the heat and air conditioning in the room?
Yes, as it relates to everything.
No, I'm asking specifically about the heat and air conditioning.
Also that, specifically that, yes.
Okay.
I requested a continuance because I need to be able to, like I say, lay a foundation and call Ms. Collins. I'd like to call Mr. Branson. I'm trying to subpoena and call someone from the city.
Okay, so counsel, I've heard your request for a continuance, and I'm not likely to grant that right now, because this is now the 4th date that the parties have been back. This is the 3rd date that you've been here.
No.
Didn't you start on the 14th?
No.
Weren't you here on the 14th?
No.
Oh, no, you were not. This is the 2nd day you're here. I'm sorry. So which witness are you intending to call regarding the heat and air conditioning in the upstairs front bedroom?
I'm intending to call Mr. Branson and Ms. Collins.
Okay, well, then call them right now. They've been sworn in under oath.
Okay, but the problem is that I need time to deal with the exhibits. I still need a continuance, Your Honor. It's my 2nd time here. This is in less than a week. So I'm sorry that the plaintiff's procedural history is in whatever state it's in. However, again, whether, you've explained to me it's not a motion for summary disposition, but I can't emphasize enough that number 7 is just not true because it's not in compliance with local laws. That's what I was intending to discuss today. And of course, if, we need to pull the evidence to talk about that, that's fine. But the problem is, I still need to be able to give my client a fair trial. And I don't feel I can do that under these circumstances. It would be different if I had been before you for a month, Your Honor. I would understand.
The compliance portion regards applicable state and local health and safety laws. Okay? The ordinance that Mr. Branson may or may not be in compliance with based upon the certificate of compliance or certificate of occupancy is an ordinance, not necessarily something that falls under the health and safety laws. So, the issues that we have to, so I think at this point I'm going to dismiss the motion, I'm going to deny the motion to dismiss because the court doesn't find that the defendant was not being, or the plaintiff was not being truthful when he declared that the residential property was kept fit for the use intended, has been kept in reasonable repair. Reasonable repair doesn't mean 100% in repair during the term of the lease or license and is in compliance with applicable state and local health and safety laws. Okay, there hasn't been any condemnation notice put on the home. There hasn't been any other citations that Mr. Branson has received that would call into question the health and safety of the health and safety laws as it relates to this property. Now, the other issues I indicated that I was going to address regarding the escrow, where the money goes, okay? Are you prepared for that?
No, I'm not. I was prepared to come here and discuss a motion to dismiss based on the fact that there's no certificate of compliance. It's pretty straightforward in a lot of other circumstances.
What's pretty straightforward, counsel?
Like if you're in a locality and they check that there's no certificate of compliance, then it's illegal to rent the property. So the complaint has to be dismissed if it's for non-payment of rent. It has to be treated like someone's squatting. You have to issue a 30-day notice to quit. You have to proceed like this. You can't proceed, and she's paid, so there's
Where's the law that supports that?
Okay.
Where's the law that supports that if Mr. Branson does not have a certificate of occupancy or certificate of compliance, that the tenant then has to be treated as a squatter?
That's not what I mean, Your Honor. What I mean is she's been sued for non-payment of rent. She's all paid up in rent. But if there is an issue where there's not a certificate of compliance, you hold a different opinion, but I've stated over and over again that 7 cannot be complied with. That's why a lot of cities are putting into their ordinances specifically that these an eviction cannot be, a judgment of eviction cannot be issued against a defendant in these cases because of that.
But MCL 125.530 indicates an action can be maintained. So if the state law and the local ordinance are in conflict, which one prevails?
It's silent in the local ordinance, but it does say you cannot rent without a certificate of compliance. It's still an illegal occupancy.
So then that is an issue that Mr. Branson will have to deal with the city of Wyandotte if they choose to issue anything regarding him renting property without a certificate of compliance.
Right.
So how does that fall under violation of a health and safety law?
Okay. I'm a little pulled in 2 different directions. 1 second.
Your Honor, while may I respond to her arguments, Your Honor? If it would
just for a moment.
Thank you.
I guess I need clarification. Is it the court's contention that ordinances cannot be health and safety laws?
I didn't say that they could not be health and safety laws. What I'm asking is what is the authority that states that the ordinance, right, and not complying with the ordinance is a violation of the health and safety law? That is what I asked.
There's not an assumption when there's a law written to protect health and safety that that's what it's for.
You're telling me that a certificate of compliance is to protect health and safety?
Absolutely.
Okay, where's the connection for that?
Because a certificate of compliance, a city goes in and does an inspection. A certificate of compliance in this case in particular, because obviously you can have commercial ones, is for residential use. That
That's to make sure that the tenant is safe and it's up to city code. That is the point. It is absolutely to protect the health and safety. It's absolutely pertinent. It's a health and safety law.
Where is the law that states that the ordinances of a locality that addresses rental properties falls under the health and safety laws of the state of Michigan?
Your Honor, I'm sorry if you're sick of hearing it, but I'm not sure how much longer we have to go. I again need to request a continuance. I wasn't anticipating being on the 5th hour, after it was scheduled, that's all. That's the reason. And I have other important business matters that I'm missing.
Okay, Council, when we scheduled this date, nobody said anything about having any time limitations, or else I would have addressed that at that time.
I didn't think it was reasonable that this would be this long.
So are you stating that it's unreasonable that it's going this long?
Frankly, with the situation in terms of the clear violation where cities are responsible for the public safety, health, and welfare, and that involves having proper licensure to collect rent under a lease agreement in a residential property, yes, I think that it should again be dismissed on that basis.
Okay, ma'am, Council, you're making many leaps without having any connections to get you to the other side. Because even under the Michigan Occupational Safety and Health Act, I have yet to see anything that would tell this court that a rental certificate falls under the Safety and Health Act. So I'm denying the motion to dismiss. I'm not denying your client or yourself, counsel, a fair opportunity to present evidence. Now, as it relates to the issue of the June rent, we also have the security deposit, which I think, as we all know, that you can't do anything with that until after Ms. Collins moves out to determine what. I'm sorry, what?
I'm gonna stay until the end of my lease.
No, that is not what this court ordered.
This is, if you're gonna say that this is habitable and I've been paying my rent the entire time.
First of all, you just interrupted the court as I'm talking. Now, Ms. Collins, you stated yourself that you were moving out. You did not want to stay there.
No.
You did. You stated that on February 7th or 14th.
No. You took my words and you twisted them, Your Honor.
I did,
Yes,
right?
yes, you did.
Okay, so what is it you said, ma'am?
Your Honor, this right now is the only place I can stay.
No.
Right now, I just found out my cancer is
That's not what you
bad.
said. No, that's not what you said. What is it you said?
I am 100% paid up to rent. This is an eviction. If I did not pay my rent,
Ma'am.
I was gonna have to leave. I'm
Ma'am.
staying until my lease is up.
Ma'am,
I
What is
appeal
it?
this.
excuse me.
I'm appealing this.
What is it that you said?
Then I'm gonna stay here.
No.
Yes, I did. I said that day that if you're gonna make me pay, I was going to stay. That's exactly what I said that day.
I asked you if you.
That's exactly what I said.
I asked you if you wanted to keep living there. You said, no, you don't. You said, I will gladly move out.
No, I did not.
Yes, you did.
No, I
Because
did
then
not.
we got into the discussion as
No.
to the escrow money and who gets the escrow money. Because you said that I need my money back so I can go find a place to live. That is how that conversation went. So, the other issue that we have to address is the escrow money.
Your Honor, is there any way we could resume at another time with the rest of this?
I'm going to pick another date. I just want to make sure we're all on the same
I'm
page.
just trying to get somewhere. Okay, yes, the utilities.
Okay, anything else?
I don't think so.
I need a timely manner to figure things out.
Yeah, I'm not telling you have to leave tomorrow.
Thank you.
I'm not saying that at all. Because I also recall that you say that you've been looking for places to move. So to tell me that I took your words and twisted them, ma'am, is not accurate.
You did.
Okay?
Your Honor, I
So-
think you also requested that she provide to you the names and addresses and phone numbers of the people that he's contacted.
I will not get that to the court.
I did request that, ma'am, because you stated that you needed a certain amount of money to move out. So I was trying to facilitate some sort of resolution between the parties. That is why I asked you for a list of where and the cost that it would take for you to move there.
I'm looking at the cost right now is roughly between $4,000 to $5,000, so.
Okay, that's why I asked you for something in writing to present to the court. Because I have some credibility concerns based upon what's been presented to me and only wanting to give me partial information.
It cost me $5,000 to move here into this place.
So I did ask for you to submit that information to the court as well.
I will have that next time in front of you, Your Honor.
So we're going to have everybody return. We're going to pick a date. These are the issues that we are going to address. Everybody, I'm expecting to be prepared. I'm also expecting that there is going to be productive communication, conversation, exchange of information, whole information between counsel.
Hello.
Your Honor,
Yes.
I was attempting to discuss the utilities issue with Ms. Kennedy outside as per your directive last time.
Okay.
And she would not go talk to Mr. Ali Dagger about what I was saying. That's why I said I needed to speak with him. She would not go and communicate what I was speaking.
I'm talking about the email that went.
Right, but it's just a little bit harassing to me, honestly. That's the problem.
Your Honor, the real issue is that there was an email sent out where we asked Ms. Declala for information. It was that email. Ms. Kennedy followed up and said, hey, we needed these things from you. Ms. Declala responded to that email with abject vitriol towards Ms. Kennedy, telling her that she was, like, go get your boss. Like, you're not practiced to law. And then I responded. And
Right,
I said,
I reviewed all of this.
yeah, and
yes.
I need this information. And she told me, go get Ali. Like,
I didn't know who you were.
I had a notice of appearance on file, ma'am.
Okay, well, I hadn't seen it.
You were emailed it to my men.
Please stop.
You were emailed my.
I am exhibiting respect.
Okay, she's indicated
I
that
just
she
want it to
sent you.
stop. I just want to focus, I'm sorry. I just want to focus on the issues in the case.
Okay, but I will also say, if there's this much emotion between counsel, it's going to be hard to focus on the facts of the case and the resolution of the case.
Thank you, Joe. When do you want us to come back here? I know, we're all excited to come back.
March 14th.
Thank you for that.
Yeah, the escrow will continue, Your Honor?
Yes,
That's fine.
Thank you for giving me that time.
Which day is that on, Your Honor? So that
it's a
doesn't-
Friday.
Your Honor, I work on Fridays.
Ma'am, I can appreciate that, but we have to get this matter resolved. I'm trying to give enough time so that there can be the information, excuse me, I'm trying to give enough time for the information to be retrieved and exchanged.
Yes, Your Honor.
And enough time, if there's any witnesses that need to be subpoenaed, to be subpoenaed.
Yes, Your Honor.
Thank you so much.
Thank you.
So, I would plan to be here for a number of hours,
Okay.
okay?
Yes.
I don't know how many hours that is, but I plan to be here for a number of hours,
Thank you, Your Honor.
okay?
Thank you.
All right, thank you.
Take care.
Thank you. Oh, I'm sorry, hold on. The court did receive another order for inspection. And, counsel, I'm going to have you both look at it quickly, just so you can see what it is that the court's signing and that the provision regarding the third-party interference with automatic show causes, that was removed.
I will not allow police on my property though this time, after what happened last time. I'm putting that on the record.
I don't know what happened last time. I don't know what happened last time. I haven't.
Oh, you should see the video.
They asked for my escrow account. They said that I'm in Rainbow Tenant Court and they didn't believe what was going on. It was a joke.
I'm sorry, but we have another hearing. I really have to go.
Counsel, I understand, hold on a minute. Miss Collins, just a moment. Counsel, I understand that, but I also am trying to prevent what I can foresee happening on Tuesday, Wednesday. What day did we say, the 26th?
That's 26, yeah.
That's Wednesday.
I would like for, if necessary, for the police to be there.
No.
I think to maintain.
No.
Please.
I was
Hold on.
pushed aside and told I could not go into any room.
Absolutely not.
I have it on my security cameras as well. I was pushed aside and told I couldn't go into any rooms because I was in landlord-tenant court. I had to show them my escrow papers or they weren't gonna believe me.
Absolutely not.
Not anything you asked for to happen.
What?
Not anything that you asked for to happen. I said, no, he's supposed to take pictures that I want to. They said, this is a joke.
No. I did not state, but counsel, you don't have to point at me.
No, I'm sorry, I apologize.
I did not say only the pictures that you want. That is not what I said.
No, I know that.
What I said was that Mr. Branson was to take pictures of the areas that you were stating were of concern. That didn't prohibit him from taking photos of other areas of concern that he had, okay? And that was specifically brought up on the record.
He wouldn't do that. He wouldn't take any pictures I asked him to. And they said they weren't gonna make him.
Ma'am.
It was a joke, and I don't want police in my house.
Ma'am, let me just say this, okay? If a city inspector feels the need to contact the police because there may be a disturbance or there may be some concern
I
or
would be
other,
very nice, but they're not.
excuse me, please stop interrupting me and we're not done.
Heather.
We're not done, please come back up here. I cannot tell the city inspector they cannot call the police, okay? I cannot tell them that. So what I'm saying is,
He's gonna call them, they won't.
ma'am, Mr. Branson, here's what I'm going to say. There's not a need for civil standby during the inspection. There's going to be an independent person there, the inspector, and I expect everybody to be on their most adult, appropriate behavior for the entirety of the inspection. That means not communicating in the ear of the inspector as to what they need to look at or anything of that nature, okay? The inspector knows what their job is that they have when they arrive at the home. There should not be any videotaping. There should not be any video recording. There should not be any audio recording. There should not be any communication at all, other than, hi, how you doing? Welcome to my home, whatever, something simple like that. That is it.
I promise you that, Your Honor, except for my security cameras, correct? Our security cameras out of there.
I don't know what your security cameras, would they go on when people walk in? I don't know what that is.
Okay.
I don't know what that is.
I promise I'll be exactly civil this time, 100%.
If the city inspector feels the need to contact the police for whatever reason, that is their right. That is their prerogative, okay? That is what I'm saying. I'm not prohibiting a third party who's not under the jurisdiction of this court from contacting the police.
Thank you.
Thank you so much.
Thank you. Have a good weekend. We'll see you back on the 14th at 10 a.m.
Sounds good.
Do you know what you just said?
Wait, hold on. Please come back.
Hold on. Please come back.
What? No.
Mr. Gander, what is it you just stated to my court officer?
As I stated, Your Honor, as she was leaving, she called
Who's
me,
she?
Miss Collins called me a name, asshole.
I did not. I swear I did not. 100% I did not.
Well, ma'am, you flipped him off last week.
Okay, so you're gonna believe everything he has to say?
Ma'am, I said you flipped him off last week.
Okay, and I admitted to it, did I not?
You admitted to it.
Yes,
Okay.
and I am not admitting to this. And I admitted to things I said in the hall. I'm not gonna admit to something I didn't do. I admit to things I do.
Okay, so I'm gonna have Miss Collins and Miss DeQuala for you to please leave.